Very true. All right. Ready to get started again? Alex McBeth, thank you for being with us. Obviously, you're one of the two finalists, and you're no stranger, I don't believe, really to anyone here. And we again appreciate you for being here, and congratulate you on being one of the two finalists. Just to familiarize you with the process, what we're going to do is essentially have 2 rounds of questions. And we will started with Ms. Helton the last time. We'll probably start with Mr. Cagle this time, and we'll work one question, Mr. Cagle, one for Mr. Sewell, work our way around and then back. And then if there's anyone that has an additional question afterward, then we can ask that. But it's essentially 10 questions or so. Anything I'm missing? Right. We did have one citizen who asked a question, or requested that we ask a question of both candidates. And so we did ask Mr. Litchford, we'll ask you as well. Have you ever represented any of the council members here on this dais?
No, I believe so. Okay. I certainly have not. I'm fairly certain that the Chambliss firm is not either.
Okay. Thank you, sir. All right. And with that, we will go to Mr. Cagle.
Mr. McFay, I've seen you in action before, so could you explain how you defend our governmental city out here on lawsuits brought against us by businesses and individuals?
Certainly. Thank you for the question, Mr. Cagle. The charter requires that the city attorney not only manage litigation, but I think the term directly manage the litigation involved, that the city's involved in it. The city or an interested council member that they're particularly involved with as it concerns city business. So I think with that comes a level of responsibility with respect to actual lawsuits brought against the city, and also as the city brings against others, that requires the attention and time of the city attorney. Now I understand that we do have insurance coverage. We do, the Municipal League does provide with us additional legal counsel for the instances when an individual or entity would sue the city. Still, on some of those cases, and I've been, I guess, most directly involved with a particular case involving a fireworks tent sales entity out of the Nashville area. Those cases, I spent a considerable amount of time on those cases. Now, in retrospect, is that time required in every instance? I wouldn't necessarily say so. I think there are certain cases where the Municipal League attorney, the insurance defense attorney, can certainly provide adequate legal counsel to the city. However, it's in the charter. I mean, it's paramount that the city attorney also have direct supervision over that litigation. And that can mean a variety of things. It can mean reviewing his briefing before he files it. It could mean, actually going before a judge and arguing if you do not believe that that particular insurance defense counsel is adequately representing the city. But there is time that will have to be spent in those lawsuits. And I mentioned the fireworks tent sales, and I actually can say today, I think we prevailed on that lawsuit brought against the city by that fireworks Mid-America, that fireworks tent sales, and they are not appealing that decision either. So we prevailed in the one major piece of litigation that I've worked on in the last couple of years with respect to the city. There's obviously some ongoing pending litigation that I was previously involved with that's still ongoing, so I won't comment on that litigation here today. But it is important that the city attorney has their hands in every piece of litigation that's brought before the city. It's required by the charter.
Thank you, sir. Mr. Sewell.
Describe your knowledge in the building planning and zoning area in reference to building and housing code.
Certainly. We, as part of my practice at Chambliss, first of all, the Chambliss firm, and obviously I'm here today as the key the attorney from my firm to serve as the city attorney. But I listed in my application, I think you all received about 10 or 12 or so other attorneys. Most of those other attorneys solely practice in the area of real estate and zoning law. In particular, one such attorney, Michael Stewart, served prior to Mr. North and Mr. Anderson as the interim city attorney. He is purely a real estate and zoning attorney. He will also, if this council would allow, in the event I was ill or if I could not make a meeting, he would be the attorney that I would recommend fill in my stead, as I had done for Mr. North and Mr. Lutheran did for Mr. Anderson. I would recommend Michael Stewart, and he's agreed to do that. But I've personally gone before the Regional Planning Agency, representing certain clients, wanting a particular variance, wanting a zoning change, some of these business persons in Chattanooga. I have had experience before that agency and also going before the actual city council in Chattanooga, for instance, asking for a variance or some type of change for that individual. So I have experience with respect to Hamilton County and Chattanooga. But also, as it relates to East Ridge, I've spent, as I think I mentioned previously, I've spent the last 3.5 years really probably speaking to Kenny Custer more than my own family members. So I think that he is a great codes official. We've become intimately familiar with the International Property Maintenance Code, International Building Code, all of which the version that East Ridge has adopted. I've drafted substantial briefing on behalf of the city as it concerns certain lawsuits that are, as it concerns our administrative hearing officer, our city court clerk. There's one that's currently pending involving jurisdiction of the administrative hearing officer as it relates to building, code violations, other violations. I wrote all the briefing prior to Mr. North's resignation, turned all that briefing over to our defense attorney, who I think he pretty much used verbatim all the briefing that I had prepared. So, in addition to being familiar with those folks at the Hamilton County and the planning agency level, City of Chattanooga, obviously the City of East Ridge, I've worked quite a bit with Mr. Custer. I think I'm fairly familiar with his work, with the codes, the ordinances that relate to our zoning provisions here in East Ridge. And also, I want to point out one other thing too. We have a separate, it's called the zoning ordinance. And if I don't get a chance to say this later, I wanted to point this out today. One of the areas for improvement, if you will, that I would recommend is Ms. Middleton is tasked with the huge task of keeping up with all of our ordinances over the years. And every so often, she has to work with MTAS and get a compilation of our city code and our zoning ordinance. There are quite frequently questions that come up, and we have to bombard Ms. Middleton with, I need the latest version of X, this version of the zoning ordinance, why, I need this, I need that, and she is an amazing employee for the city, but I don't think she should be the only one, keeping track of the current state of the law of East Ridge. I think that the city attorney needs to create a database, a searchable database, similar to what Chattanooga has. So we're not just relying on that one MTAS ordinance every 10 years to know what is the current state of the open air ordinance. Because as you're aware, there's some instances where multiple ordinances will amend the same code provision. So having an up-to-date city code, searchable city code database, Muni Code does it for Chattanooga, Memphis, but having a database that anyone on this council can go search open air ordinance, it will bring up the current state of the law as it relates to open air. It will reference all of the ordinance amendments to that code provision over the years, and it needs to happen. It needs to happen for Ms. Middleton's sake, for all of our sake, that there needs to be a way in which the city attorney can point to the zoning ordinance and make sure that Mr. Custer has the correct zoning ordinance. Because I guarantee you right now, Mr. Custer's binder, does not have every up-to-date provision of the zoning code as we currently have. I mean, it does, but it's scattershot. I mean, it's hard to read. There are different ordinances he has to go through in order to tell somebody, constituent, yes, this is the law, if they were to call them. Same thing for our office. To answer these questions, it is tedious, and it does not have to be that way. If the next city attorney really keeps track, and every time an ordinance is passed at this council meeting, to go back that next day, update the database so that citizens can instantly check the current state of the law as it concerns zoning ordinance and also the rest of our city code. I think it's vital for our city moving forward.
Thank you, sir. All right, let's see. Can you provide an overview, I mean a 30,000-foot view of the Board of Region Retail Tourism Development District Act, or what is commonly referred to as the Board of Region Act?
It was passed in 2011. Senator Bo Watson, Representative Lundberg, also in the Northeast Tennessee area, in addition to Representative Dean here in East Ridge, passed this act to essentially allow cities who have these tourism districts within 12 miles from a bordering state. There's also some other qualifications. You have to have access to a certain number of tourists, potential shoppers, certain $1 million number of revenue that you could generate. But there had to be some qualifications that a city could put forth that they would meet. East Ridge, as well as a couple other, Kingsport, Johnson City. You know, we were able to capitalize on this piece of legislation that I think the Commerce and Insurance Commissioner was not even, or Economic Development Commissioner at the time was not even overly in favor of, because he saw how big of a carrot they were giving to some of the cities that chose to capitalize on it. We luckily, this council's mayor and folks had the foresight to capitalize on that. It allows, it returns a percentage of the state sales tax money back to the city that they're able to pay for the cost of construction of these projects, a rebate, kind of so to speak. With respect to East Ridge's border development district, obviously you know the area along Interstate 75, Bass Pro Shop area, but also portions of Ringo Road that we've also drawn into the map. I think we redrew our map recently to make sure we're not including some older areas that would actually bring down our required spending. As council's aware, we've tinkered with that. And it's a great act. The sponsor of that legislation in the Senate, Senator Watson, who is the Finance Committee Chair, I worked closely with him, worked for him in 2008 to 2013. He's actually publicly recommended me for this position. I'll be happy to speak to any one of you about my qualifications, but as the author of the Board of Region Act, he's actually recommended my hiring as to this position. In addition to him, I've worked closely with Representative Gravitt, Senator Garnhire, those folks at the state level that we obviously had to in the past and still have to have a close working relationship with as it relates to the Board of Region Act moving forward.
Excuse me, thank you. Mr. Williams.
Okay, well, dovetailing right off the Board of Regents, then, can you describe your experience in negotiating and drafting development agreements between property owners, developers, for new construction and for any existing reconstruction of existing structures?
I'm part of my firms, as I mentioned earlier. I'm obviously a very large firm. Channels has over 60 attorneys. It's been around for a long time. We are known as a municipal law litigation firm, but our real estate section is also one of the best in the city. I've worked with Michael Stewart, also Andrew Leffler, who is Michael Stewart's associate, on a daily basis. Usually when I'm involved, I'm a member, as I believe Mr. Litchford is as well, of our firm's litigation and risk management section. So that is my official department that I'm in. So typically, the way a litigator is involved on these issues is on the back end when there's been a lawsuit brought. And then you get to go back and currently there's a case right now where one of our helping work on Mr. Stewart's cases where he was sued on a construction, or lease to purchase construction option agreement. So, so on the back end, it's, that they get, some of the real estate folks get a little deal because obviously we go and point out all the things they should have done differently. But hindsight is a blessing in that respect. But on the front end, I've not physically drafted on the front end one of these. I mean, it's one of the blessings of being part of a firm like this is that you have folks that specialize solely in that area. So obviously, if it did come to actually drafting the language of such an agreement, would work closely with those folks and overseeing. But I have, I mean, as Mr. North's kind of assistant city attorney the last 4 years, I've reviewed with Mr. North numerous agreements that the city has drafted. Helps him review those as well. So I've kind of looked at different angles, but to answer your question, never personally directly drafted those, but certainly have attached them as exhibits to, or reviewed them as exhibits to litigation.
Ms. Hill?
Can you describe your knowledge in the personnel areas of personnel rules and regulations?
Certainly. Once again, I've been involved in a few lawsuits involving our labor and employment section. The firm has a very large labor and employment section, super lawyers listed there. Bill Pickering, who I think I listed on my application as well, current city attorney for Lookout Mountain, Georgia. He's also one of the heads of our labor and employment section. So I've worked with him representing some large companies that have been involved in disputes with their employees. So, whereas not necessarily a locality, it's certainly analogous in the sense that I've worked with the CEOs and CFOs on that have been sued by employees for various reasons. I've also worked, I've gone to and spoken at workers' compensation hearings, the workers' compensation board administrative judges that we have in Chattanooga. So I've worked with those folks, but once again, it's typically in the form of litigation where one of our clients has been sued by an employee, disgruntled employee, and we have to work with that person either to settle that dispute or to litigate it. And I think there's certainly nothing wrong with settling lawsuits, and you obviously want to do what's in the best interest of the city. But some of the personnel disputes, can be, my section is litigation and risk management. So you manage risk on the front end, but in the event you have to be involved in some litigation, sometimes it is necessary, to vigorously defend the city when a disgruntled employee might, contend they were treated, poorly or for some reason that's not correct. Now, in the event there is a legitimate claim and a dispute, I've been involved with some disputes involving the city under Mr. North's tenure. Certainly is in the best interest to work out an amenable resolution to that dispute for everybody involved. I've worked with Mr. North to do that in certain instances, and obviously with the firm as a whole.
Thank you. Ms. Hill? Yes.
Can you talk about your knowledge in the area of nuisance laws and how the city can implement programs to eradicate derelict businesses that constantly engage in prostitution, drugs, gang activity, etc.?
Once again, I'll fall back on my numerous conversations with Mr. Custer as it relates to a lot of these areas, but there's clearly defined case law when it comes to some of these industrial nuisances, pawn shops, prostitution, massage parlor. I mean, there is well-defined case law, and also MTAS. I think probably a fourth of their opinions concern nuisance law. And so speak with Alicia Hodge at MTAS on a weekly basis on these as well. Now, there are various programs that can be done. I mean, obviously, as we've spoken in the past, particularly with respect to, I'll mention Superior Creek as an example, you can't seem like you are picking and choosing winners and losers, but when it comes to nuisances that are clearly defined in case law as having bad primary and secondary effects for the citizens and the city, you can obviously implement, I would say, neutral legislation to attempt to try to preempt some of those disputes down the line. One such example would be the apartment rental inspection program that some cities are a part of, and that East Ridge and others could join. But to be able to go in and have our codes officials be able to go in and inspect some of these apartments that illegal activity potentially are coming out of, that they are a nuisance in the sense of the activity, but also in the state of the buildings. And we had this with Superior Creek when, I was actually directly involved with Chief Williams in the condemnation of Superior Creek. Mr. North was out of town on an emergency, and then I had to come in with the interim city manager and with codes enforcement officials, and had to make a call to condemn the building on a night when there was going to be a huge rainstorm that came. It was very tough. Everyone saw it in the news. It was a very tough decision that we had to make. But but when it came to it, the safety of those citizens, I mean, our codes folks could not say that someone would not be severely injured or killed in that building that evening. And so it made the decision, simple. It had to be condemned. And luckily, we had church officials, we had church members, we had city officials all come out to help that evening. But it is an example of some things on the back end that I've had to do, but also realizing what you can do on the front end to try to prevent some of those from spreading. I think that rental inspection program is a great example.
Can you provide your capacity and capability to handle day-to-day matters as well as in short notice and timely manner situations as a city attorney?
I think this is, this is once again paramount for your city attorney. The city has made a decision with its two finalists to not have an in-house full-time city attorney with respect to someone being physically present at the city all the time. But and obviously as we mentioned, I'm sure Mr. Lisford mentioned, there are positives from that arrangement. One, being able to call on the expertise of a large firm that can handle a variety of matters. With that being said, though, it is a full-time position. The salaries we are requesting, it is salary that is most likely higher than most full-time city attorneys in the area. I'll use Chattanooga for an example. Now, obviously, they have a whole department of city attorneys. They have assistant city attorneys they can call on. So if you were to take, the sum total of all of their employees, in addition to insurance, the research databases that attorneys are required to use, that amount would be quite higher. So to compare them, apples for, you're comparing apples to oranges when you try to compare that. So there's obviously a certain benefit of hiring a firm. But with that, though, I expect, and you can expect from me, to be directly accessible via cell phone on an hourly basis. If I'm in court, I've provided a list of 10 other names that you can contact directly as a council member for any legal advice as required in the charter. But also in the event that there's, any staff concern, if he needs to know if he can condemn this building this afternoon, you have to be accessible. So with that, I've listed numerous folks, but also obviously the paralegal that has served as our municipal paralegal for the last 4 years for East Ridge. Peggy Bates has agreed to again be our go-to paralegal that anyone on this council can call if for whatever reason I'm in court or not accessible. But it has to be direct communication. I would be if lucky enough to be hired. The city attorney is the city's attorney, time and tail, but also each one of the council members and staff members attorney when they have day-to-day questions, and so you have to be able to be reached. I'm accessible via email, phone call, cell phone, office phone, full-time assistants, paralegals, and other colleagues that will answer your question. If a question can't be answered, a lot of times there's research that has to be conducted. If that's the case, then you need to be aware of that. This is going to take 5 hours of research time before I can get you an answer that I'm comfortable with. Is that short enough time for this turn? There just needs to be communication so that you guys can decide, how to move forward on certain issues. But it's vitally important, and I think I've had a good history of being accessible through the council as I've served and as interim for Mr. North at times. But he was the primary contact for a lot of you folks, and obviously that would change. It would I'm not saying I'd be more accessible than Mr. North, but I certainly, he's a very busy man, and I certainly got a lot of calls from you guys forwarded to me at times, and was happy to take them, and I would be more eager to take them now as the city attorney. So, yes, but it's very, very cool.
Thank you.
Right. Obviously, we've had several questions. You've been able to tell us a lot about your experience with municipal law. What can you tell us, again, just from a broad perspective, what can you tell us about your previous experience working with municipal law or areas of law that would be relevant to Eastridge that maybe you haven't already talked about?
I do think it's important, in addition to some of the large labor and employment disputes, and also construction disputes that, construction litigation that we have been part of, that I've served, worked on. So, as I mentioned earlier, I think one area that I'm uniquely qualified in concerns my past experience working with the state of Tennessee. I think it's in my resume, but I was the only non-attorney at the time head research analyst for a major committee, and it was the Judiciary Committee. So I was the youngest, I was the only one without gray hair and without a law degree at that time, but it made me, that job actually made me know that I wanted to go to law school. And while I was at Vanderbilt, I actually continued to work for that committee. But what I was able to experience that I think are quite unique, and I'm blessed to be able to do, was just to really understand the daily interaction between localities and the state. And we are a home rule municipality, and with that, we are given some additional opportunities, responsibilities that other cities aren't, in the sense that, we don't necessarily have to go to our delegation every time we want to turn or change the bill passed, but there are still state laws applicable to what we can and cannot do that will trump our local laws always. In essence, the way our Constitution is set up, and we can't get around that the need to be able to pick up the phone and talk to someone knowledgeable in a certain area of state law, to have those relationships. The Speaker of the House of Representatives spoke to her this weekend. I would be glad to talk to each one of you. Most likely will be running for governor. Beth Harwell recommends me wholeheartedly. The current lieutenant governor, previous lieutenant governor, would be happy to take questions if you had like to ask him about my time serving. But served at that level, being able to pick up my cell phone and call the attorney for the state and local government committee to see how our law contradicts, potentially conflicts with the apartment inspection law. I mean, it's important to have those connections. So I do think that I'm uniquely qualified, that I do have those connections and that experience actually drafting legislation. I worked every bill that came to the Judiciary Committee. I would review, draft amendments, prepare summaries. Every single bill that was voted on, I actually prepared a red line summary showing how the current law proposal differed from the state of the law. Something that we do at times here, and Mr. Miller has done a fantastic job of his executive summaries, kind of giving in a nutshell a summary of what the bill does. But still, I think having the current state of the code with a red line, what is being taken away, what is being added, so you can clearly see what you're voting on, the effect it's having on the current city code. I think that's very important to have, as it concerns every ordinance. Every time we amend our code, we need to know exactly what you're amending to make sure there's no unintended consequences on a bill on an ordinance that might do X, but down the line we realize we accidentally allowed it to do Y too. So I think it's important to have those summaries. But I think, what I haven't mentioned, I think that it's just my experience working for the state of Tennessee for 4 years. I was the main liaison with all the various lobbyist groups, the various departments, worked with numerous mayors, county mayors, department heads, in drafting and seeing their legislation pass through, and really understanding the state of the law, and explaining to the senators that are on my committee.
Thank you, sir. Mr. Sewell.
The experience simply, I mean, my experience has been working with the city of Chattanooga, and also with Hamilton County. I think that obviously something that we should consider, that we can consider. But on those, when I worked with Mr. Hinton, the city attorney of Chattanooga, who also, I can say this, also publicly recommends my appointment, as well as a reference I listed, the city county attorney for Hamilton County. Worked with them, but once again, it's on the back end of some disputes. Now, on the front end, our real estate section has to work with various housing authorities across this region. Have experience doing that. Something that if the city were to, as a policy point of view, if you were to adopt it, then obviously we would have the folks there to help make sure that all the applicable federal, and it's, with housing authorities, you're dealing with a lot of federal rules and regulations. So it's vitally important that you have folks experienced in those that can work with folks at the federal level in seeing that through. So, but once again, not firsthand experience on a daily basis, but that is the pro of being a part of this very firm that I could call on.
Thanks, sir. Mr. King.
Again, mine's gonna be kind of like a three-part question here. On conflict of interest here on your application, states, wanting to know if you're representing any city employee, any council member, any company that we do business with or anything. And also, I recommended to get some clarifications on the conflict of interest rule, and the city manager and I had a conversation about one of them. It was a 1.7 and a 1.10C. And the 1.10C, it says for you all to get around the conflict of interest thing, you set up what you call a Chinese wall. So could you define the Chinese wall where we can understand it, or how your firm would go around getting around the conflict of interest on this?
Well, politically correct term is an ethical screen, not the Chinese wall, but the ethical screen law is one that most states have. With that being said, it is part of our rule of professional responsibility. That's the rules that all lawyers have to abide by when you can and cannot represent current and potential and former clients. That provision, it's an example. If there's an office that has a firm, if there's a firm that has an office in New York City, but then also a satellite office in Los Angeles, these attorneys and staff never interact. There's no chance that confidential attorney-client information would be spread. These offices are distinct, they're just part of the same firm. That would be a case that an ethical screen could reasonably be set up to allow for the joint representation of two clients, a client in LA, a client in New York. Their paths will never cross. They're not going to be working, or not going to be involved in a lawsuit. It's an example that the rules envision that it would be an unrealistic prohibition to try to keep that LA firm with their client, from being able to represent them because of potential conflict with that New York office. The Tennessee Supreme Court has looked unfavorably on ethical screens. The case law interpreting ethical screens are they don't particularly like it. They know that it sounds great on paper. That what you're reading right there sounds all good, and if you can implement one, then you can do it. But in Tennessee, the Supreme Court has said we just don't see that being done on instances. That doesn't involve a 250-person firm. In Tennessee, a lot of our we're one of the second largest firms in Chattanooga at 60. Most firms are a lot smaller firms, and they just know you share staff. If I were to be, say, if I were to try to set up an ethical screen
with a potential adverse client and in the firm, they know that, let's say if I was setting one up between me and Mr. North, well, Mr. North and I share a paralegal, share assistants, our offices are near each other. The Tennessee Supreme Court, if there was a dispute involving two clients, they would not be overly happy with the so-called screen that we set up. And that is just the case law as it interprets these rules. There's not a lot of case law on it. Because a lot of times what happens when you see these cases being litigated is that it's a disgruntled client. Let's say somebody were to sue, get involved in a lawsuit, and they realize, well, my attorney helped the other side more. They will file a suit to get that whatever law overturned or get that contract tossed out. So a lot of times it's on the back end. And so there's not that much case law, but Tennessee Supreme Court, there are reported cases where they do not look favorably on these ethical screens. And it's just because they know it's not realistic. But how would you go about setting one up? Well, if a client of the firm, and I'll use Chambliss as an example. I think the mayor had previously mentioned the Times Free Press in the past, the client of our firms. For one, there wouldn't really, I can't particularly envision an instance where there would be competing legal interests between the city and the Times Free Press. But let's assume that there was. Let's say there was some defamation action that someone on the city were to, that they thought that they weren't materially legally adverse to the Times Free Press. Well, then you could ethically screen off those attorneys, lawyers at my firm that represent the Free Press, and ethically screen me, who represents East Ridge, in a manner where all computers, all files had to be password protected. The secretary would have to be reassigned if they work for the attorneys on both sides. I mean, there are things that you have to implement to make sure that confidential attorney-client information did not pass from one lawyer to the other, and that you could sufficiently represent both clients' interests. They'd also have to obtain a waiver. Both of the clients would have to agree, yes, I want to allow Chambliss to continue to represent. I'm okay with it representing you and you. Both clients have to sign off on that. So there are things that you can do. At the same time, I might propose that in such an instance, the better course would be to recuse yourself from representing either client. In these rare instances where this conflict arises, it could be in the client's best interest, East Ridge and the Times, to obtain their own new counsel with respect to this one dispute. Because the last thing you want is a court to overturn some action or to say, no, this ordinance, we're tossing this out because your city attorney was conflicted out. He represented both parties. He was supposed to be providing unbiased representation for the city. At the same time, he was allowing his client to get something, before the city. I mean, that's the last thing you want is for that ordinance or for some contract to get tossed out by a judge. So it could be in the best interest of both clients that you recommend their own legal counsel, different legal counsel for this one dispute. So there's theoretically, there are certainly ways to set up this ethical screen. The Tennessee case law, the Tennessee Supreme Court does not look favorably on them. That's kind of all I can say.
All right. Is there anything else?
Yes, I forgot to mention in that questionnaire, are you or your firm either one have or are representing the WWTA?
I don't believe so. I don't believe, I certainly am not. It would have to be, if there was a certain dispute
We ran a lawsuit with them out here.
with them. We're not currently, to my knowledge, representing them. Have we ever in the past, I'm not sure, I have to check that, but I'm 90% positive that firm is not.
Anything else? All right. Thank you, Mr. McMillan.
Thank you.
It's
It's
appreciated
really been an
very
honor
much.
last 4 years being able to work with you guys. I appreciate it regardless of how you guys vote. Thanks for the opportunity.
Thank thank you for interviewing with us. Do we need another short break, or would we like to proceed? Are we good? Okay. All right, well, here's the opportunity to take action. We certainly can do that. We can entertain a motion to make a hire. We can, if we need more time to process the information we've heard, we can certainly take that time. It's the council's pleasure. We can discuss what we've heard before the motion is made. There's not a,
We're going to discuss, I'd like to make a kind of overview comment.
sure,
After talking to both of them, Mr. Ledger's firm has offered us, I think, he said 3, 4, himself and 3 other attorneys to come in and serve as backups. He's also offered the whole 25 firm. He's listed 3 of the firm's names here, where Mr. McFay here has come in with 12 names. Now those 12 names, we got 6 of them that's got municipal government, governmental laws, government affairs, city attorney. One of them here, one's on Lookout Mountain. One of them represents the Metropolitan Airport. Then we've also hired Nicole Osborne to represent us in Nashville as a lobbyist. So then they've got 3 people here that are, their specialty is zoning, real estate. And they've got the environmental person, just like the electric firm does. So we've just got 12 people here to contact. When Mr. McFay is not available, we've got 3 people here to contact. Mr. Letcher's here. We've got a whole list of their resumes, and only one of them, other than Mr. Letcher himself, has government law. So that is something I'd like for everybody to take into consideration. Like Mr. Gentleman out there was talking about the salary. It helps on budgetary because we know what this firm's wanting, we know what this firm's wanting, but we don't know what the end of the year this firm's going to be, so.
Well, I'm gonna bring up, and I want to say that I think both these gentlemen are both fine attorneys. One problem I have is Mr. Norton's here. We hired him at $90,000. That's what he agreed to do it for. He came back. He personally told me that he realized that there was more to it than he thought. He wanted an increase. So council at that time gave an increase. And then they came back again, another increase. So it went from 90 to around 130,000. So what's to say that they want this won't happen again? You know, it's, Al couldn't do it for 110, and he would leave. I guess part of there, we get into a lot of litigation, a lot of talking about housing authority, we're talking about a lot of other things coming on board that's gonna take a lot of manpower. And Mr. North came to us and said that the firm couldn't work this type of salary. So what, that's the only one problem I have. Salary.
Mr. City Manager, well, what's the final salary, Mr. North? 120.
it was 132.
That was, it was 11,000 a month, yes.
So, in that same vein, go back and I distinctly remember conversation here, and I actually went back through the videos of our council meetings. I found it November 12th of 2015. If you look at part 3 of those clips, starting at the 32-minute mark, about 30-second snippet. This is when we were talking about increasing the attorney pay from 120 to 132. The question was asked of Mr. North. Correct me if I'm wrong, this is, Mr. North, this is the firm requesting this increase. And Mr. North replied, this is the firm that indicated to me that because the volume and number of people working at a reduced rate, that it's problematic. It's problematic at 120,000. It wasn't because Mr. North's rate was being discounted. The volume and number of people working at a reduced rate was problematic.
So now we've got the same firm going to come back for 110.
Kind of feel like the customer who's, and I don't, believe me, I don't see him over there, but Alex, I'm not putting any of this at your doorstep, okay? Or wherever you are over there. There he is. You know, I kind of feel like the longtime customer who decided to change companies. Oh, but we'll offer you this, this lower rate if you'll stay with us. That lower rate could have been offered previously. Again, I'm not putting that at Alex's doorstep. I feel like there was, well, it's not hard to figure out what I think. So I have a problem with that, and absolutely, I agree. There's not a way of knowing what we will end up paying for legal services if we go with Mr. Litchman. There's just not. We don't know what kind of litigation is going to come down the road. We just don't know. And I agree with Mr. Sewell. I think both attorneys are very fine attorneys. I think we do well with either one. My opinion's been pretty consistent throughout the process. It hasn't changed.
May I speak? I don't know if anybody else checked references, made phone calls, but I called this morning and I wasn't able to talk to Alex's references. I left messages yesterday, one with Mr. Taylor, and the secretary called me back, but he never did. And the other one was from the airport, and he may have tried to call back, but when I called him back, I wasn't able to speak with him. But I talked to 4 of the 6 bars, and this is some of the things they described. He's responsible, thorough, does his research, knowledgeable, resourceful, well-prepared, well-connected, skilled, personable, easy to work with, enthusiastic, a good listener, dependable. I can't say enough good things about him. And I just think when you have 2 impressive, qualified candidates, you gotta look for that one thing that sets them apart. And, for me, it was that. I like the fact that there's 3 key attorneys that we would be working with at Mark's firm. I like more of a personalized service. I don't want to have to deal with new people, every time an issue arises. And I think that's just a very positive thing on that. Like I said, I think they're both very qualified, but Another thing that set Mark apart from me was his association with Candy Animal Shelter. We've all been talking about the new animal shelter here in East Ridge at some point, and I really feel like he will be very beneficial in this process. And for that reason, I'd like to nominate Mark Litchford as the next city attorney permanent.
And since it's stated that way, that you would nominate him, we do need to, and I'm going to rely on my limited understanding of Robert's rules, but we have a kind of a similar situation to what we saw December 29th, where the name's been placed in nomination. I'm getting a little head shake down here yet, so keep me on the right road. So we have one nomination. Technically, even though we only have two candidates, we can receive a nomination for the other candidate. And then we vote on, we can close nominations, we have to make a motion to close nominations, and then we can simply vote on the choice. So do we have another nomination?
I'd like to nominate Mr. McFay.
Okay. Those are the only two options we have, so I will entertain a motion to close nominations.
Make a motion to close nominations.
We have a motion, do we have a second?
Second motion.
Roll call, please.
Vice Mayor Sewell,
Yes.
Councilmember Cagle,
Yes.
Councilmember Hilton,
Yes.
Councilmember Williams,
Yes.
Mayor Lambert.
Yes. Mr. Litchford's nomination was made first. We will proceed to a, I remember how this was done. Oh, I do remember now. It's simply we'll go through the line and you say the name of the person you vote for. So, all right, if, Ms. Middleton, if you will, go through the roll call, please.
Vice Mayor Sewell,
Mark Litchford.
Councilmember Cagle,
Mr. McFay.
Councilmember Hilton,
Mark Litchford.
Councilmember Williams,
Mark Litchford.
Mayor Lambert.
Mark Litchford. The council has voted in favor of Mr. Litchford. I think he may still be back in the kitchen. I don't know. Okay. Well, I want to, again, express thanks for Mr. Litchford, but also Mr. McVeigh. And I don't know if he would accept me as a client, but I would have absolutely no qualms going to Mr. McVeigh to represent me in whatever situation I was dealing with. I do think very highly of you, and I appreciate you very much. With that, we will adjourn this meeting.